going to start off with State versus Tishio. And the argument of Tishio was on the 5th of November, 1986. And the central issue in Tishio was whether or not the Supreme Court was going to continue to allow the defense of retrograde extrapolation to be a viable defense in New Jersey. And Evan, for just some of the newer attorneys here, can you tell everybody a little bit about what retrograde extrapolation is, please?
It's reality. It's alleged intoxication at the time of driving. So in New Jersey right now, we have State versus Samarel that gives up to 3.5 hours pretty much for the state to bring somebody to a breath test machine or even blood. Blood's unclear. But let's say your driver is, and absorption, alcohol absorption is physiological, obviously. You're either rising or you're expelling the alcohol from your system. If you're rising, it's obviously the more time that you get from the time of the stop, it makes the reading higher. But if you had a couple of drinks earlier, more than 90 minutes is full absorption, generally physiologically, then you might be coming down. So you obviously, if you're on the rising blood alcohol, you want to have a defense that says, hey, at the time I might have been 0.10, but or I'm sorry, 0.07, but now I'm a 0.12. Let's talk science and reality. But Tishio took that out. So
let me kind of take 2 steps back, because I want to kind of get this, how it's going to come out and how it's going to play out in Ray Edson. So the whole theory behind the defense of retrograde extrapolation was as follows. You're in a bar or somewhere consuming alcoholic beverages, all right?
I'm signed in, right?
Like any other substance that goes into your body, it has to go through the stomach and then get absorbed into the bloodstream. The alcohol is funny this way, because alcohol can actually be absorbed into the bloodstream through the stomach, but most of it goes in through the large and small intestines, okay? But the bottom line is that it takes a while for the alcohol to move from your throat into your stomach, intestines, and into your bloodstream, and then ultimately up to your brain. So what would you say the average would be? Like an hour or so for complete absorption, hour and a half? How long would it take alcohol completely to be absorbed into the bloodstream? So would there be nothing left in the digestive system? How long would you say on average?
Generally 90 minutes.
All right. So
20 to 90.
Well,
right. You are right, Mr. Sitzler. It depends on physiology, and burn-off rate is different for everybody.
Context of stomach.
Right. And partition ratio, which the whole fallacy of breath testing is based on, is individual. So we are dealing with a very, very unscientific measurement in breath testing, but it's what we've got.
But the bottom line, in terms of just to set up the legal argument here, that the people in that era, back in the 1980s, early 1980s, they would argue that the BAC that they gave at the police station is not reflective of what their BAC was at the time that they were stopped, the time they were actually operating the vehicle. And especially in a closed case where you're dealing with a 0.10, 0.11, you could have an expert come in who would say, yes, well, given the fact though that he consumed alcohol 45, 50, 60 minutes earlier, his theoretical BAC at the actual time of operation would have been under the per se limit of 0.10, or that was the defense. And the appellate division had already previously ruled in Tishio on this. This is where you get this very famous language about drunk drivers being ticking time bombs. And there's some other language in the appellate division which actually survived more than the Supreme Court's decision in Tishio. But that's really what this was all about. The appellate division said that you shouldn't be able to raise this as a defense. And it was argued before the Supreme Court on November the 5th, 1986. All right. John Sitzler, don't sneak away now. I'm going to require you to be an expert witness on this next part, because this is your client. George Lincoln Edson had an ethics case before the New Jersey Supreme Court, which was argued in May of 1987. So we're talking 6 months later. Nothing had happened in terms of deciding the Tishio case, but now the court is confronted with a real world example of retrograde extrapolation. Let me kind of set the table for this. George Edson was a Burlington County defense attorney, did a lot of municipal court work, and he had a scam that he had worked out where clients would come in and they had drunk sufficient so that there was a marginal type reading of 110, 11, something like that. he would set up a defense of retrograde extrapolation and hire an expert to come in and prepare a report. He would then take that report, go to court, and try to negotiate some type of a disposition other than drunk driving. Is that pretty accurate description of what George was up to in those days?
Yes.
All right. And then one day he had a client come into his office named Hoppe, Hoppe. Tell us about what happened with Mr. Hoppe, Johnny.
Again?
Yeah, tell us again.
Okay. Mr. Hoppe was a 0.14, and he came into Edson with this theory that he was taking massive doses of zinc, and that would have altered the breath test reading. And of course, that's nonsense. And Edson goes through the drinking pattern with him, and he says, well, you can't say that because that makes you guilty. But if you happen to drink 2 large iced teas, the alcoholic beverage iced tea, right before you left the bar, it could then get you under.
Johnny,
What becomes problematic is that when he goes to court, he gets the deal he wants, okay, which is a reckless driver. The client won't take it. Makes him go to trial. Of course, when he brings in the expert, he puts on the perjured testimony, etc. And Dennis McInerney convicts the guy. And first of all, everybody needs to know, because they weren't around back then, retrograde extrapolation really only works when the numbers are close. Where when you have to go into one of these situations where you get what's a dumping effect. In other words, you drink a lot of alcohol in a very short period of time. Most people die from alcohol poisoning when they do that. But assuming that you could, it doesn't happen frequently in real life.
And Johnny, one of the other attributes of it, the drinking has to be end loaded. In other words, the majority of the drinking has to take place before you get into the car and start driving.
That's the dumping effect.
Right.
End loaded.
Right.
Okay. And it's normally, man, and it's actually quite effective when you get a guy that's right at the margin, say he's a 1-0. And he said, look, I had my last drink was 10 minutes ago, and I just drank it and left the bar. Right. You know, you're maybe going to get that guy to be an 0.85 or an 0.9. You're not talking about huge movement here. Mm-hmm. So on a 1-4, understanding that's a big lift to start. They go in and they try the case and they lose. Hoppe takes an appeal. And in the appeal, he alleges his own perjury as a reason to reverse the conviction.
This is before Judge Haynes?
Judge Friedman. Judge Friedman, Vic Friedman.
Okay. Judge
Friedman denies that, okay, but refers Edson to the Burlington County Prosecutor's Office for a criminal investigation. Mm-hmm. That's where I get in. Edson gets wind of this and he comes to me. So I go over and I convince them that they don't want to indict him, but they refer it to the ethics committee. And then we have a hearing at the ethics committee and Hoppe testifies. But in the meantime, what they did during the prosecutor's investigation, they dummy up a drunk driving case. They create a police report, the tickets, all the documentation. This is before the days of videotape. So they just sent this over to Edson when he requested the discovery. But the way he gets the case is they have one of their senior detectives, a guy by the name of Neil Forte.
He used the name of Captain Frank Furillo, the same name as the TV character that was so popular in that year.
Hill Street Blues. Walk him into Edson's office. He gives Edson a completely benign description of the driving and drinking conduct. Edson says to him, this is all on tape. Says, no, you can't say that. They'll convict you. Here's what you need to say.
I'll tell you what you had to say.
I'll tell you what you need to say. And he tells him.
Right.
Okay. And at that particular point, and look, it's just amazing that he didn't pick up who this was, because he had 2 state troopers standing in his office. And when Forte walks out, they go, hi, Neil. Okay. He didn't even pick up on it. So the long and the short of it is we tried the case and we lost. And it went to the DRB. And this is the interesting part. The DRB was split, Disciplinary Review Board. They had 3, I think it was 7 or 8 members at the time, maybe 9. But They split. 3 of them wanted a 3-year suspension. 2 of them wanted the disbarment. And I think the other 2 or 3 voted for a suspended suspension, which he could have gotten at the time. Of course, the Supreme Court made short shrift of any of those arguments other than we are pulling your ticket forever.
But Johnny, listen, before we get into the actual analysis of the opinion and the defenses that got canned because of this, it's important, especially for the younger lawyers who, in our age, or everybody compared to us,
Is younger.
You really got to understand what the practice of law was like from 1979 until
Even before that, you couldn't plea bargain.
Well, I know that,
Not
Johnny,
even so much as a parking ticket.
but the whole tenor of the court was so utterly controlled by Chief Justice Wilentz. And, this was his show. He was
Well, that's what you're seeing the pushback on now from Scutari.
Correct.
With the plea bargaining, with the appointment of the appellate division judges by the governor as opposed to ascension through the ranks, they have finally said we've had enough of Wilentz's bullying with all these issues.
You have to understand that so much of policy that he determined personally on the bench, and he had associate justices who went along with him, drunk driving, combating drunk driving, ridding New Jersey of drunk driving was one of the very sincerely held judicial belief he had. And he had the same feeling with other issues, the Graves Act and the Graves Act and things of that nature. But for the younger attorneys, you really have not experienced someone who ran the court personally, every little tiny detail of it. And there were very few judges who would stand up to him, Martin Haynes being a notable example.
Well, he would do crazy stuff too, Bobby, rather than allow things to proceed in the normal course of litigation. If he didn't like a particular decision, he would call that judge up. I know, for instance, you mentioned Martin Haynes. Martin Haynes decided the case of State versus Paris, which I'll let you pontificate on.
I was just thinking about Paris a moment ago, actually.
Well, so you can tell him what it was about.
Right.
He decided it was a defense decision. Wilentz called him up on the phone. And I know this because Martin told me. And he said, he read him the Riot Act for this.
Yeah, well, yeah, actually, now that I think about it, Paris is actually another disallowed DWI defense. The case gets argued, though, on that particular day, May the 4th. And I have to tell you, this was a bombshell that went off in the Supreme Court. These justices were really upset and used enormously extraordinary language in the disciplinary case. Let me read to you some of the language that the court had in their opinion. They said that the following: the record is clear that respondent advised 2 clients to manufacture evidence in the defense of their drunk driving cases, contrary to RPC 1.2D. Respondent also knowingly permitted a client to offer false evidence in trial and counseled and assisted a witness to testify falsely in a trial. Respondent also participated in a fraud by giving false information to his expert witness for the purpose of having him testify under oath in reliance upon those facts. And he gave information to a municipal court. He gave false information to a municipal prosecutor. Okay, that's the setup here. That's what the facts were. The language the Supreme Court utilized in this case is utterly extraordinary. You don't see this kind of language ever. And when they use the expression, something shocks the conscience of the court, this Edson case shocked the conscience of this court. Listen to this language. There's making a reference here to the tapes that were made by the undercover investigator from the Burlington County Prosecutor's Office, the undercover detective who came and pretended he was a client. Here's what the Supreme Court said. One need but listen to the tapes. The reaction to what is portrayed is at once fascinating and chilling. The members of this court are not babes in the woods. We are invested with at least minimally acceptable levels of sophistication, of worldliness. Our professional backgrounds have exposed us, in varying degrees, to some of life's seamier aspects. We have traveled on different roads in our professional careers. We have practiced in different fields and encountered collectively all kinds of lawyers, mostly very good, some perhaps indifferent, and a mere handful bad. In short, we've been around enough that not much surprises us. But rarely have we encountered in our colleagues at the bar the kind of shocking disregard of professional standards, the kind of amoral arrogance that is illustrated by this record. There could hardly be a plainer case of dishonesty touching upon the administration of law and arising out of the practice of law. And the bottom line coming out of this, apart from disbarring him, I think the justices sat down and said, we just this one guy doing this stuff. How many other lawyers around the state are engaged in the same or similar type of questionable, shady, or outright illegal procedures with respect to retrograde extrapolation? And I think the justices met, and I think they came to the conclusion in deciding Tishio that we're going to put a stop to this, and we're going to put a stop to it now and forever. And you see, on June the 30th, so approximately 2 months later, the court comes out with the Tishio decision, which bans the use in perpetuity, basically, of retrograde extrapolation as a defense. Now, it's interesting. Let me just read over the language that the court used in this Tishio decision and the justification they had for getting rid of this defense. Here's what the court said. The overall scheme of these laws, the DWI laws, by the way, just Johnny, you brought this up, so I want to kind of have everybody else think about it. Could contrast this language to what is going on right now with respect to what the court said and what the legislature said, and that led to the withdrawal of Guideline 4 permitting plea bargaining in drunk driving cases, and see how things have changed over the years. Here's what the court said in Tishio. The overall scheme of these laws, the drunk driving laws, reflects a dominant legislative purpose to eliminate intoxicated drivers from the state. Now, nobody ever questions whether that's even possible, whether it's ever happened in the history of driving, but okay. To this end, the legislature, working in tandem with the courts, has consistently sought to streamline the implementation of these laws and to remove obstacles impeding the efficient and successful prosecution of those who drink and drive. Now, when I read this back in 1987, I guess, there were 4 decisions in addition to this on that particular day. That was drunk driving day for the court. But I thought to myself, why is the judiciary surrendering its independence and joining forces with the perceived partners they have, in the legislature and with the governor? Why are they doing that? Whatever happened to independence of the judiciary?
Well, he was always a legislator.
Well, I understand that, but it was shocking language to me then. I think they have some dicta. Evan, is that true? Am I recalling this right, that in the beginning of Chun, they kind of backed down from this a little bit? They altered the language slightly in the introductory language of State versus Chun. Is that true?
A little bit to allow defenses, and even more so in Olenowski.
Well, Olenowski is the polar opposite of this, and I'm going to get into that in about 2 seconds. But I just want everybody to know that this was shocking language at the time. And this is where Olenowski comes in, just in terms of modern day jurisprudence. One such, oh, by the way, the obstacles impeding the efficient and successful prosecution of those who drink and drive. If I'm the law clerk for the chief judge, actually, I think Justice Handler wrote this, but if I'm the law clerk, I would say, hey, Mr. Justice, time out for a second. It's not against the law to drink and drive in New Jersey, okay? That's not an offense. You can't drink while you're driving, that's number one, and you can't drive while you're under the influence of alcohol. But for you to have a drink and then drive your car, if you're not under the influence of alcohol, you haven't violated any statute at all, okay? But I digress. All right, thank goodness I wasn't a law clerk. I was barely born then. One such impediment has been the introduction of conflicting expert testimony at trials under 39-450. The vast majority of statutory revisions in this area have been directed toward minimizing, if not eliminating, the necessity for this type of evidence. And that makes this Olenowski 2 jump off the page at me, because that is a case where the Supreme Court encourages, mandates, just expects that there will be conflicting expert testimony, especially from the defense side. It's a highly favorable defense case. Wouldn't you agree, Evan?
It's inviting defenses. It's almost at this point malpractice not to have medical defenses if they're available, or asserted defense where the evidence, they are basically saying it must be challenged.
So in 1987, the idea was quick justice, speedy justice, no experts, short summary trials, everybody's guilty, move on to the next case. We're going to eliminate drunk drivers from the roads of New Jersey, okay? I'm not sure that worked out all that well. But now in 2024, with the publication of Olenowski, that you just can't say that that is part of our jurisprudence any longer. Rather, it's a much more even, measured approach. And I have a feeling it's really kind of stems from the leadership on the court. I don't know. I'm not in the room when they discuss these things, but it's a stark contrast between 1987 and what's going on right now. The court went on to say the following: accordingly, we hold that the statute prescribes an offense that is demonstrated solely by a reliable breathalyzer test administered within a reasonable period of time after the defendant is stopped for drunk driving, which test results in the prescribed blood alcohol level. Prosecution for this particular offense neither requires nor allows extrapolation evidence to demonstrate the defendant's blood alcohol level while actually driving. Now, this interesting language here, Justice Handler, throughout the opinion, keeps alternating back and forth in terms of what the relevant time is in putting this defense together. So is it the reasonable period of time, does it begin when the defendant is stopped or when the defendant is arrested? And many times there's a huge amount of difference between those two. And if you go through the opinion, I think the final score was 5-2 or something of that nature in terms of, and I forget which one it was, but it's very sloppy in terms of how they alternate back and forth. This reasonable period of time stuff was thrown in there because the defense claimed that the police would purposefully delay the administration of the breathalyzer test to allow any residual alcohol in the defendant's body to be fully absorbed into his body through the intestines and through the natural resources, so that natural bodily functions. So at the time that they administer the test, he would have reached his maximum level. And I think as a sop to the defense bar, the court threw in this reasonable period of time issue. My experience has been reasonable period of time can be as much as 3 hours, maybe even more. Johnny, what's your experience with that? 3 hours, 4 hours?
You're not going to get much more than 3 or 4 out of it, but that I agree with that.
The case law in Samarel and Gordon is pretty much 3.5.
Okay. So I want everybody to kind of know about this. And the interesting thing is that extrapolation is not only permitted, but it's also required in the Superior Court when there is a prosecution for an alcohol-related homicide, vehicular homicide, aggravated manslaughter, aggravated assault, assault by auto. In other words, anytime that the reckless element is going to have to be proved by consumption of alcohol, it's incumbent upon the state to demonstrate that the recklessness and the alcohol consumption were, kind of occurred simultaneously, and they've got to tie that to the time that the defendant operated the vehicle, okay, to prove recklessness. So in the Law Division case of State versus Oriole, which came, fairly quickly after Tishio, the Law Division said the following, and by the way, this case has been approved by the Appellate Division many, many times. It's just an indispensable component of prosecuting these types of cases. Here's what the Law Division said back in 1990 in Oriole. This court holds that extrapolation evidence of the defendant's blood alcohol level at the time of operation is both relevant to and probative of whether the defendant Oriole acted recklessly. The state therefore will be permitted to adduce evidence of extrapolation analysis based on the defendant's blood alcohol reasons taken at the hospital in order to show that the level of the defendant's blood alcohol concentration when the collision occurred. At trial, the state may introduce extrapolation evidence on the issue of whether the defendant acted recklessly under circumstances manifesting an extreme indifference to human life as charged in the indictment. So I guess if you're in municipal court and the state wants to rely upon extrapolation for some reason and they do it, do you think, Evan Laveau, would you think that would allow you as a defense to come back with a countervailing argument from your own expert saying that the extrapolation is wrong, faulty, or whatever, as an affirmative defense? What do you think?
If that court is going to violate the law, then yeah, they should let me violate it too.
Well, it's not a violation of the law. The Law Division says you can do it. And by the way, it's done in every county throughout the state. It has to be, because how else are they going to be able to prove recklessness at the relevant period of time?
Well, that's really, it's really at the Superior Court level. I have cases pending now for assault by auto where they're doing extrapolation, and obviously, like you said, in any sort of homicide case. But I've never seen it in the municipal court. I wish it was available.
John Sitzler, are you still there somewhere? You've done quite a number of vehicular homicide cases over the years. For some reason, you always get your clients acquitted. I'm not so sure what's going on. I'm very suspicious. But do you run into this State versus Oriole retrograde extrapolation business when you try these cases?
I have not run into that. It's never been an issue in any of the ones that I have, primarily because most of them are blood tests.
Right.
Not that you don't have that issue, but it's you see it less. Where I think that it's going to become really fascinating currently is when you get an accident with a drunk and somebody else is injured, and it's referred up to the county prosecutor's office. They decline to prosecute the indictment, send it back as a simple assault. Now you're in municipal court with a drunk driving and a simple assault criminal. But now you mean to tell me this is the problem I always had? Oriel says I can extrapolate on the criminal case, but not on the DUI.
Right.
How does that work?
Well, I just want everybody to understand the parameters of what's going on with retrograde extrapolation, okay? The ban on it in 1987 as a result of State versus Tishio, the impact that it had on attorney disciplinary law, and actually, I think one feeds into the other. In other words, the Edson case really got the justices torqued up on this, and they wanted it banned outright in perpetuity. Everybody should understand Oriel, though, and that you may be able to use retrograde extrapolation if it's been posited in some kind of context, either up in Superior Court in a criminal case or in municipal court, which I think could happen if they wanted to prosecute a simple assault as a recklessness standard. Evan, do you want to add something to this?
Yeah, I have a case pending right now in Superior Court where the blood reading is a .079, and the guy's driving with a beer in his lap in a cup, and he's drinking as he's driving. Mm-hmm. And the state wanted to do extrapolation on that one. My argument on that is a little mixed. I mean, if he's drinking at the time of the accident, the alcohol's not even yet in his system.
Right.
So, but they will get an expert. They'll have somebody write a report on the extrapolation issue, and now I have to do the same.
We actually, we're going to be talking about a case that has very similar facts, State versus Lizotte, another law division case.